The Colorado Supreme Court kicks Trump off the ballot, and unfortunately, I think this is just the beginning, unless the Supreme Court steps in and does something pretty aggressively to knock this nonsense off to save American democracy. But in this case, the Colorado Supremes decided it was in their purview to disenfranchise over 1.3 million Coloradans who presumably are going to go out and vote for Donald Trump. They said, you don't have that right anymore. We're Democrats. We believe in democracy unless you get the opportunity to vote for somebody that we don't like. And this is a shocking opinion, one of the most troubling opinions I think we've ever actually covered on this channel, and we've covered a lot of them. But we're going to go through the full ruling from the Colorado Supreme Court and then get reaction from the lawyers who worked on the case and the Secretary of State and others. But remember that there has been no finding of insurrection against Donald Trump. Not in the indictment, not in the impeachment resolution at all. Remember, this is what the indictment charged Trump with. There were 4 crimes. And if you see seditious conspiracy or insurrection in here, please let me know. I haven't been able to find it. Count 1 is conspiracy to defraud the United States. Oh, a conspiracy charge. Oh, another conspiracy charge. About what? Obstruction. Okay. We also have actual obstruction, which is another not insurrection charge. And then we have a conspiracy against rights charge, which we think they should be charged with. But the point is, no insurrection in the indictment. Okay. So the Justice Department presumably reviewed the case, didn't find it was there, and didn't bring the charge. So why can Colorado just presume that there's been a conviction on that, or that this has already been conclusively defined? Well, because they just decided they wanted to do that. But as far as federal law goes, he has not been indicted for it at all. And moreover, he still has not even been impeached on this, because remember, the second impeachment that was brought under H-Res 24 actually did charge Trump with insurrection. Okay. This was their bite at the apple. This was the moment that they were supposed to get rid of Trump. They put him on trial already and they lost, which is why they're trying to do it again and again and again. But you don't get to do it as many times as you want until you get a conviction. So remember, this is what this one said, HR 24 in the Senate, saying that we are impeaching Donald John Trump for high crimes and misdemeanor. Why? Incitement of insurrection. Okay, so he was charged with this. We have something in this country called double jeopardy, and he was charged here. They said that the Constitution provides under the 14th Amendment, okay, the same issue that we're litigating in Colorado, which has already been litigated right here, said that Donald Trump violated his constitutional duty by inciting violence against the government of the United States. And that's a pretty interesting standard there, because people might say, you know, Kamala Harris did that when she was donating to the Minneapolis bond funds to have people who burnt down the 3rd precinct in Minneapolis released on bond. Okay, they actually incited violence. Maybe it wasn't against the government of the United States, maybe it was against the government of Minneapolis, but you get the point. So on January 6th, they say Donald Trump met, and shortly before he said, we won it by a landslide. If you don't fight like hell, you're not going to have a country anymore. Okay, this is already part of an original charging document. They said that he interfered and his conduct on January 6th was something that was problematic. He instructed Raffensperger to find the votes, and then he demonstrated that he's a threat to national security. Okay, this stupid document was signed by Nancy Pelosi, and Cheryl Johnson, the clerk, signed off on it too. So we've already litigated this. Guess what? Donald Trump had this brought in front of him. We went through due process. The left likes to howl about that. And then they went into the Senate and he was acquitted. So now they want to do it again. Right now, since all of the other mechanisms has failed, now since he's already been indicted 4 times, they're trying to take away his business with Tishy Latish James. They're trying to defame him out of oblivion with Miss Bergdorf, who got Bergdorfed allegedly, never happened. And the list goes on and on. And so now we have the Colorado Supreme Court. And this is something that really hurts. I mean, in American political life, in jurisprudence, for the foreseeable future, you know, you can compare and contrast this ruling against the Trump indictments. Look, you're always going to have hack prosecutors, okay, who are partisan and political. And we've got that. We've had that in Washington for years. We get that all the time. We know what a corrupt district like Washington, D.C., the D.C. Circuit looks like. That's not a surprise to anybody. So the fact that they go to the World Criminal Court, just, you know, pull Jack Smith out of some, you know, pod somewhere and then inject him into the American political life and just say, go get him. Doesn't matter. Forget the Constitution, whatever. Go get him. We understand that mechanic. And Judge Chutkan will rubber stamp him. And we always rely on the higher level courts to reintroduce some normalcy, okay? Some sense of sanity to the things that we do. That's why we have the courts of appeals, because it's supposed to get more sane as you go up. And we're going to see if that happens or not. But in this case, the opposite has actually happened, right? This is far removed from Washington, D.C. This is a whole separate state, one of 50 that we have. This is a group of 4 judges, not just one, right? This is not brought by a hack political prosecutor. This is brought by a private interest group, okay? Meaning that anybody can just go pay for somebody to file a lawsuit. As long as you have the right issue in front of the right people, you might get some judges somewhere to do it, right? And this is 4 judges at the highest court who have sworn obligation to uphold and protect and defend the Constitution, all in the name of the constitutional republic on which we are built. But they have decided, the 4 of them, to literally disenfranchise 1.36 million people who voted for Trump last time. Those people will not get to vote for him again if this stands. And the idea that they would do something like that is so antithetical to democracy. I think a much bigger blow than anything we've ever seen before, quite frankly, on this channel, because it is just the scope of this. And what this does, as we've already predicted, is it emphasizes the ability of other courts to find the same way. They can say it's persuasive authority and they can just pick over what Colorado did and use it as cover. And so it is a reprehensible opinion. I think that we're all Coloradans now, right? They came for Colorado. They're going to come for the other states. And this is literally the judicial class. It is the Democrats not even playing around anymore, right? It's just taking it away from the people. And I want to think about this in reverse. If they're going to sit here and take this away from us right now, what do you think they did in 2020 when you were challenging it on the other side, right? You're challenging it in the courts. The courts just say, we're not going to hear your claims. You think they give it the time of day at all? I don't. Because if they're willing to do this, it shows what they're willing to do elsewhere. So without any further ado, let's get into the opinion so we can really break it down. This is what it looks like coming out of one of the most anti-democratic and one of the most disgusting opinions I think we've ever seen ever, which is stripping the right to vote for a candidate away from the people in America, in one of our states. You don't get to vote for the person you voted for last time because 4 judges just decided it. Wild times ahead. But this is what the judge and these legal scholars write. They say, in this appeal from a district court proceeding, we now consider whether Donald Trump may appear on the Colorado Republican presidential primary ballot. Now, a majority of the courts hold that President Trump of this court holds that Trump is disqualified from holding office under the 14th Amendment. And because he is disqualified, it would be wrong to list him on the ballot. Now, a big asterisk here. The court stays its ruling until January 4th, subject to any further appellate proceedings. Now, there are a lot of caveats in this, and there's a lot of different ways this thing, I think, can go. But if you really want to get hyper technical, you could say, well, if it's all going to be stayed, is anything going to change at all? Let's zoom in and see what's inside. So, as you can see, the case comes from the Supreme Court of the state of Colorado. It is brought by the CREW organization, and we have a bunch of different people involved. Not only the people who wanted to get Trump removed, which is this group of people, we've also got the Colorado Secretary of State and the Colorado Republican State Central Committee, along with Donald Trump. And so there's a bunch of different issues here, and we're going to try to hit the highlights on what's happening. Tons of attorneys. This has been working its way up to the Supreme Court. We've covered this from the beginning, starting with Judge Sarah B. Wallace at the lower level district court. And so it begins with a little bit of a background here. Where do we begin? More than 3 months ago, a group of Colorado electors who are eligible to vote, both registered Republicans and others, filed to get Trump off the ballot. Now, invoking the provisions of the Electoral Code, they said that Trump's name on the primary ballot, they said he was disqualified under the 14th Amendment. Now, after permitting Trump to intervene, we had a 5-day trial, which we covered extensively here. And the lower level court found that there were 2 prongs. One, whether Trump engaged in insurrection, and the judge said, yes, he did. But the second prong said did not apply, right? He committed an insurrection. The 14th Amendment doesn't apply to the presidency, therefore Trump is not removed. But they say wrong. We affirm in part and we reverse in part. And we hold the following, that the election code allows electors to challenge Trump's status based on Section 3. They say this is their only viable means of litigating this. And so this is the only mechanism, the only action they can bring. So almost as a technical procedural mechanism, this is the right way to do it. Congress, they say, wow, Congress does not need to pass implementing legislation for Section 3 to attach. And it is self-executing, okay? So the previous prongs on the mind map that I showed you about the indictment doesn't matter because it just executes itself. You can just decide, right? In other words, a Secretary of State at a local state level can just execute this. In other words, I think this is something that happened, and it's self-executed. Congress doesn't need to impeach him and convict him. In fact, even if you're acquitted, okay, in Congress, even if they try you and acquit you, they can still just self-execute it, right? So judicial review of Trump's eligibility for office is not precluded by the political question doctrine. And the political question doctrine is this idea, you can't go sue your government because you hate taxes. It'd be nice if you could, but you can't. They just say, well, if you hate taxes, just go vote for somebody. That's why we live in a democratic republic, a constitutional republic. And by weaponizing all the political questions, you kind of wreck that. So they say, no, it's not a political question. This is a legitimate question. Trump can be thrown off the ballot. They tell us Section 3 encompasses the office of the presidency. Now we're going to zoom in on each of these, but Section 3 does cover Trump. He took an oath. And so Judge Sarah B. Wallace, who I think was right, was wrong. The district court did not abuse its discretion by admitting the January 6th report into evidence. They conducted their own little show trial. The district court did not err by defining an insurrection and declaring that this constituted an insurrection. And also Trump engaged in an insurrection, and the First Amendment does not protect Donald Trump's speech. So it's just like the lottery ticket for Democrats. It's like, wow, everything is going in their favor. What an incredible opinion. Now, the sum of these parts is this. All added up, the Supreme Court of Colorado says President Trump is disqualified from holding the office under Section 3 because he's disqualified. And it would be wrong under the law to then list him if he is disqualified. Now, the court says we do not reach these conclusions lightly. Sure, I'm sure you didn't. I'm sure you guys really contemplated time and again and really had difficulty ruling this. And you say, we are mindful of the magnitude and the weight of the questions that are now before us, and we're likewise mindful of our solemn duty to apply the law without fear or favor, without being swayed by public reaction to the decisions that the law mandates that we reach. Now, I got a lot of questions for who these four people are and, what type of pressure came down to bear upon them. All seven of them, quite frankly, right? You take a look at the political pressures in this country and who is leveraging what to get these rulings. Good question. Now, they say we're also cognizant that we travel in uncharted territory, and that this case presents us several issues of first impression. But for our resolution of this law, the Secretary, but for our resolution of this challenge, the Secretary would be required to put Trump on the ballot. And so, this is an interesting paragraph. They say, therefore, to maintain the status quo pending any review by the U.S. Supreme Court, we stay our ruling. Okay, so this thing is now entered, but it's on hold. It's stayed all the way up until January 4th. And we know that in Colorado, they vote for the president in the primary on March 4th. The day before March 5th, I think, is Super Tuesday. And the January 6th trial was scheduled for March 4th, if you remember that. So if review is sought in the Supreme Court before the stay expires, then the stay shall remain in place, and the Secretary will continue to be required to include President Trump's name on the 2024 presidential primary ballot until the receipt of any order or mandate from the Supreme Court. What? Oh, gosh. So you're not even going to stand by it, you weak little pathetic anti-democratic judges? So what they're going to say is that the Secretary will continue to be required to keep Trump on the ballot. And so as long as they get something filed and the Supreme Court doesn't issue a ruling one way or the other, nothing's going to change. The status quo is going to be the same. So it's a very sneaky opinion, and it really has a lot of contingencies to it. So they could have just, said it and then delegated it up to the Supreme Court. The way this reads to me is that they have some skepticism about this. They're like, I'm not sure what the Supreme Court is going to do on this. So we don't actually want to make the changes. Like, we're making the changes, we're ruling that we're going to make the changes, and then we're not actually going to do them because we kind of think the Supreme Court might mess this up. So it is kind of spineless, right? It's spineless on multiple different levels because they're not actually doing it, but they are doing it. So it's typical for a bunch of Democrats. Now, here's the background. On November 8th, President Trump was elected. We know that. Joe Biden in 2020, they allege he was elected, which I still think was rigged. On January 6th, they say the Electoral College meant Trump said fight like hell, everything happened. We know the rest of it. So now they're going to bring us to the analysis. Question is about Section 3, the 14th Amendment, the Insurrection Clause. They want to go through an overview on this and explain how it works. They say the end of the Second War brought what we called a second founding of America. And we passed a bunch of rules, including the Section 3 of the 14th Amendment. Amendment, which says that here, no person shall be a senator or representative or elector of vice president or hold any office, okay, just as a reminder, any office of civil, military who have previously taken oath as a member of Congress or as an officer of the United States or state legislature or executive judicial officer or any of the others, if they shall have engaged in insurrection against the country. But Congress, by may a vote of 2/3 of each house, removed the disability. Okay, and we've read this many times here, so I don't want to spend too much time on it. But the lower level court, Judge Sarah B. Wallace, said that this does not apply to the president. Otherwise, they would have just said president. Now, in interpreting a constitutional provision, they say, we want to really understand it. If the language is clear and unambiguous, then we can just read it. But now we don't really know what this means. And so they're going to walk us through. And so now we say the principles of interpretation apply to this, and we're trying to address the meaning of that provision. So let's see how they do it. They say, first of all, the state has the right to challenge this. We have jurisdiction, and, this is the proper claim stuff. Now, presidential primaries, they say, before addressing these things, we want you to know that we know the rules about how the primaries are conducted in Colorado. The election code limits it to qualified candidates, okay? You can't be 8 years old and run for president. Got it. So section of this law says the following, and any challenges are brought through this special statutory procedure, which, it's very technical and boring, blah, blah, blah. Section this allows you to do this. And in other words, all of these CREW people, the people who are filing the removal suit, did it right. Now, Trump argued that they lacked jurisdiction over this, but we don't think so. We think that we do have jurisdiction, and it doesn't affect any other Trump claims. And so we're allowed to hear this case because the states have the authority to assess the candidates' qualifications, and they did the proper mechanism to get here. But does the Constitution also authorize states to assess the constitutional qualifications of candidates? We conclude that it does. So the Constitution gives these people the right to qualify whether people can go on the ballot, and no party has said that they can't limit on age or residency or citizenship, right? So in other words, Trump's people are saying the secretary can boot you out if you're 8, or boot you out if you're not a resident, or boot you out if you're not a citizen. So clearly they can also boot you out if they just decide you're an insurrectionist. Now, as then Judge Gorsuch recognized, he said that this is also appropriate. Now, they say if we limit Trump's ballot access, it doesn't infringe on First Amendment rights with the local Republican entity. And here, this has been adequate due process. Okay, so it's all procedural stuff. And by performing the petition the way that the CREW people filed it, they've met all of the procedural stuff. Now, let's get to Section C. They say the disqualification provision now attaches without congressional action. This is a key point. We had questions. Is the 14th Amendment and the Insurrection Clause automatically executing? Or does there need to be a finding? Does Donald Trump actually need to be impeached and then convicted in the Senate, for example, which he was not? Does he need to actually be indicted and charged with an insurrection crime, which he was not? Or can some bureaucrat in a Secretary of State's office just make the decision? Well, it turns out SCOTUS, or here, Colorado, CODIS says that they can. We have here the electors challenge the Secretary's ability to certify that Trump is removed by calling it self-executing. They say Congress has not authorized state courts to enforce Section 3. They're saying we disagree with Trump and his arguments. They write, the only mention of congressional power in Section 3 is that Congress may by a vote of 2/3 remove the disqualification. So in other words, Congress is not even involved in this. Section 3 does not determine who decides whether the qualification is attached in the first place. So it doesn't say who does it. Now, one would infer that if the House can remove it, then the House is the entity that can add it, right? They are the people who can impeach, and the Senate can convict, and then they could, by 2/3 of a vote, remove the disqualification. But they disagree with that. The Supreme Court has said that the 14th Amendment is undoubtedly self-executing, so far as its terms are applicable to any existing state circumstances. And they reference the civil rights cases back from 1883 for that, right? So I guess every part of this is just self-executing. And so to be sure, the court directly focuses on the 13th Amendment in those cases, which is not what we're in. And they say, so this statement could be described as dicta, which means it's not relevant. Okay, dicta is just meaningless additional stuff that's not relevant, right? What happens in a legal case is a main question comes up. Is Donald Trump allowed to be on the ballot? Yes or no? And you answer that question. Anything else, like about something unrelated, right, would be dicta if you included it in the opinion. So what they're doing is wild. They're actually basing this on essentially dicta, right? They say, hey, we know the Supreme Court is self-executing. Why do we say that? Well, because it applies in the 13th Amendment. And we say, well, we're not in the 13th Amendment. Go one page over, one paragraph down to the 14th Amendment, and you'll see that statement does not apply to the 14th, right? So it is dicta, meaning it's meaningless. It has no legal weight or authority. But they say, but still, we really, really liked that quote. Like, we really needed it in there. We needed to reference a U.S. Supreme Court case, so we dug it out and threw it in there. But an examination of the 13th Amendment, the 14th Amendment, and the 15th Amendment, so now our own non-precedential analysis is, and our interpretation, which is their subjective interpretation, supports the accuracy and the broader significance of the statement. Section 3 is one of 4 substantive sections of the 14th Amendment. They say Section 1 says, no state shall make or enforce, representatives shall, no person shall, and the validity of the public debt shall. But Section 5 is the provision that applies to each of these sub-provisions, and yet the Supreme Court has held that Section 1 is self-executing. And Section 2 was enacted to eliminate the constitutional compromise. The same is true for the 13th Amendment, which abolished slavery. And like the other Reconstruction amendments, the 15th Amendment, which established universal male suffrage, contains a similar provision. And so they're looking around and just saying, we think it matches the rest of these things. And both sides can play this game, by the way. So there is no textual evidence that Congress intended Section 3 to be any different. We agree that interpreting any of the Reconstruction amendments would lead to absurd results. This has to match those things. And so if these amendments required legislation to make them operative, then Congress would nullify them by simply not passing enacting legislation. Now, the result of such an action would mean that slavery remains legal, you know? Black citizens could be counted as less than full citizens. And so they just go down the list, and it's basically absurd. Now, interveners say that there's historical evidence that requires a different conclusion as to Section 3, right? Section 3 is not like those others. We generally turn to historic and other extrinsic evidence, but there's not here. They highlighted a bunch of statements which we don't really care about. They directed us to a non-binding opinion by another case which they don't care about. And interpreting the scope of this case, we don't think it's applicable here. Now, this guy, Chief Justice Chase, made a bunch of statements, and they just go through those and diminish those one by one. Now, we're similarly unpersuaded by Trump's assertions that Congress created the only currently available mechanism to determine whether somebody is disqualified with the passage of 18 U.S. Code 2383. Now, that is an actual crime, okay? Trump could have been charged with this. He was not. Assisting or engaging in a rebellion or insurrection against the authority of the United States. And they say, yeah, you know what? That's true. They passed that in 1994. They could have charged him with a crime for that. They said, true, with that enactment, Congress did criminalize the same conduct that is automatically disqualifying under Section 3. But all that means is that a person is charged and convicted would also be disqualified. But it cannot mean that it's the only mechanism by which that they are constitutionally disqualified, not present in the text of law. Otherwise, they could just get away with anything. So they say, in summary, based on Section 3's plain language, Supreme Court decisions declaring it neighboring, parallel Reconstruction amendments, and the absurd results that would flow from their reading, they say Section 3 is self-executing, just automatic, in the sense that it disqualifies provisions attaches without congressional action. Interveners and Trump's arguments do not persuade us otherwise. Now, they say, that said, our conclusion implementing legislation from Congress that implementing is unnecessary does not resolve the question of whether doing so, and so now they're going to turn to justiciability. Like, can you even bring this claim? Can you even say that Trump should be disqualified because it is a political question? They say, no, it's not a political question. A controversy exists here. And here, President Trump claims that the case is not justiciable because, in his view, the Constitution and the federal law commit the question of qualifications of a presidential candidate to Congress. Now, they say, we address the issue again. They say, we've already provided a thorough review on this. They say, contrary to Trump's assertions, we perceive no constitutional provision that reflects a demonstrable commitment to Congress of the authority to assess their candidate qualifications. And so if Congress doesn't have the right to do it, then the states have the right to do it, right? We've got the federal supremacy clause. And so if the federal government claims the power, then the states can't do it. But because we perceive no demonstrable commitment to Congress, neither Trump or anybody else can explain why this cannot go back down to the states for them to figure it out. They say here, this involves stuff that we already know how to work with, manageable standards. They say, oh, this is another good subsection. Does the 14th Amendment apply to the office of the presidency? The Colorado Supreme Court says it does. They say the parties are asking about Section 3. Now, some claim that the source of disqualification encompasses the president. Now, Trump says it does not. And actually, the lower level court, Sarah Wallace, agreed. But Colorado says she was wrong. And they reverse. They say Section 3 prohibits a person from holding any office, civil or military, under the United States if that person is an officer of the United States and, quote, took an oath to support the Constitution and subsequently then engaged in an insurrection. And so they say, well, we have to analyze this. Does Trump fit within that definition? Now, Sarah Wallace at the lower court, that judge, much smarter than these judges, says that the presidency is not an office, civil or military, under the United States for two reasons. She said, well, the presidency is not mentioned in Section 3, but everyone else is. Senators, representatives, presidential electors, they're all listed, but the president is not. And the court found it's unlikely that they would be included in a catch-all of any office, civil or military, which was pretty reasonable. And the court also found that there was an earlier draft of the section that did include the presidency. It found compelling because it was written in the first draft. They got rid of it because they didn't want it to apply in the second draft, saying the drafters intended to omit the presidency in the new version. It got redlined out, but they say, well, we disagree. We say our reading of the constitutional text says that the presidency is an office under the United States within the meaning of the phrase. They say, very easy. All we need to do is just look at the ordinary meaning of the word, the office, rather than, he said, let's just look to dictionaries from the time of the 14th Amendment. They just went back, they looked up the word office. Office means a particular duty, charge, or trust conferred by public authority or for public purpose that is undertaken by authority from the government or those who administer it. And so they say, well, that seems like an office to me. They say, we don't place the same deference, the same weight on the fact that the presidency is not specifically mentioned. It seems most likely that the presidency, love that out of your Supreme Court. It seems most likely that the presidency is not specifically included because it is so evidently an office. It's so obvious that they took it out. In fact, no specific office is listed. Instead, it refers to any office, civil or military. And so they say, yeah, well, it's true that senators and representatives and other presidential electors are listed, but none of these positions is considered an office under the Constitution. Instead, they're referred to as members. They're not officers either. And so, indeed, even they don't deny that it is an office under the United States, but they say that they are not serving under the United States. And they say, oh no, we cannot accept that interpretation. A conclusion that the presidency is something other than an office under the United States is fundamentally at odds that all government officials, including the president, serve, quote, we the people. Now, they're referencing the Constitution here at the preamble, but I don't know that that's accurate, right? They say the president is the root power of the executive branch, all right? It's not under anything. That's the separation of powers that we have here. Now, its own power center, that's why it's such an important position. Now, literally, it is above the law. You can pardon people who've been convicted. You can order people to go to war. You got the opinion clause power that just gives you the right to have access to certain things, in my opinion. But they say no. A more plausible reading of the phrase under the United States is that the drafters meant simply to distinguish these from the state offices. And so when you start hearing things like most likely, right, this is we're just kind of shooting from the hip. We're just kind of duct taping this whole thing together. They say we think that this is most consistent. The Constitution refers to the presidency as an office 25 times, and the impeachment clause says that disqualification to enjoy any office. Okay, so the office in the impeachment clause is an office, and so we can reference that in the insurrection clause. And if the presidency is not an office, then anyone impeached, including a president, could nonetheless go on to serve as president. So this reading is all nonsensical, and so therefore we're going to find that it applies to him. They say the district court found it compelling that an earlier draft proposed and the section listed the presidency, but it did not pass. Now, we're mindful that we look back to those things, but by the way, they say we looked at the proposal, and that draft provided that insurrectionist oath breakers could also not hold the offices of the presidency unless they got confirmation of the Senate. And so we read back through that, and we can't decide what the changes actually meant. Judge Wallace was just presuming that they wanted to take the presidency out, but we think that there were a lot of other changes in there, and nothing in the speeches mention why the presidency was removed. We don't know why they took it out, okay? So you can't rely on that one. It's not reliable, and we're just going to read the text. And we conclude that the plain language of Section 3, which says no disqualified person shall hold any office, also includes the presidency. presidency. This interpretation is bolstered by the rest of the Constitution. Now, they also decide that he is an officer of the United States, and they're going to find that he did also take an oath. Finally, we consider whether the oath taken by the president is to preserve, protect, and defend the Constitution. They said because the presidential's oath is more particular than that referenced in Section 3, that they did not intend to include former presidents, right? We have a difference between the oaths, and they disagree again. No, it's basically the same. You know, the Constitution provides that all executive and officers shall be bound by oath or affirmation, and they have all got a similar duty to protect the Constitution. Now, they say it's a little bit different, but Article 2 does not include a pledge to support the Constitution. An insurrectionist president, they say, cannot be disqualified from holding office on that basis. But this argument fails. They say the president is an executive officer of the United States, albeit one for whom a more specific oath has been prescribed, right? So he's an officer, but it's just a little bit more detailed. They say this follows logically from the conclusions. The language of the presidential oath is a little bit different. It's a commitment to preserve, protect, and defend the Constitution, but that's basically the same thing as support, right? It's basically like a long way of saying support. And so we don't even need to break it down, right? They say it applies. They say President Trump wants us to hold that Section 3 disqualifies every oath-breaking insurrectionist except the most powerful one, the highest one in the land, and that's inconsistent. And so we therefore reverse that one as well. Now, they're going to go back, and the rest of these are really about what the lower level court found. And so you can see here, they say Judge Wallace did not make a mistake in admitting the January 6th report. She's allowed to do that. They also find what Wallace found. Colorado says Trump engaged in insurrection, saying that he challenges this finding. But the Constitution leaves these terms undefined, and so we've got to make a legal determination about this. Now, this is the second prong, right? And this is actually the prong that the lower level court found was satisfied. So Trump did commit an insurrection, but Wallace said did not apply to him. They are now reconfirming the insurrection finding. They say an insurrection, to find out what that means, we just look to the dictionary. A rising against civil or political authority. Wow, that's pretty broad. A rising against civil or political authority. I'm pretty sure that just happened in the Capitol building yesterday. Marjorie Taylor Greene posted about that. So I wonder if they're going to go and disqualify everybody who was on that party, right? In other words, the list is so broad, this could mean anything. Go back to the BLM Summer of Love in 2020. Go back to Kamala Harris's torching of Minneapolis, Minnesota. Okay, this is a very broad definition if you want to use that. You can see it goes on and on. But they just go back to the dictionary. Webster's, they say, we note at oral arguments that Trump's people admitted an insurrection is more than a riot, but less than a rebellion. And we agree. It's a spectrum. And so they're just going to define it however they want to here, saying the question is whether the evidence before the court established that there was a concerted and public use of force or threat to hinder the U.S. government from taking actions. And it's undisputed that a large group of people entered the Capitol. Substantial evidence established that the force was concerted and public. The mob was coordinated and demonstrated a unity of purpose, they say. And finally, there's substantial evidence on the record to show that the purpose was to prevent Congress from counting the votes, blah, blah. Now, they say Trump also engaged in the insurrection because, again, they look to the dictionary. Any overt act for the purpose of promoting. We find the definitions are perfect. Substantial evidence shows that even before the November election, Trump was laying the groundwork. Trump was saying this election was rigged because it was rigged. And by the way, we're saying it's rigged right now. We've been saying it's been rigged for months now. Ever since they indicted him and started filing lawsuits to try to remove him from the ballot, this whole thing has been rigged. Joe Biden has wanted Trump to be prosecuted for a long time, made that intimation to Merrick Garland. Jack Smith got appointed, and the rest is history. So President Trump, they say, lost the election. No, he didn't. And on this point, and relevant to Trump's case, is that Trump's efforts were subjected to a barrage of harassment and violent threats by his supporters. Trump fanned the flames. Trump was promoting conspiracy theories. With full knowledge of the violent events, he urged supporters to travel. He tweeted. He was posting mean tweets about this. Okay, the court's just going through a hyperventilation. You know, they were probably having a meltdown as they were writing this. All four of them together just circled up. Oh, include that. Include that. Moreover, the record amply demonstrates that President Trump fully intended to and did aid insurrectionists in their endeavors. And so for these reasons, we conclude the record fully supports the court finding that Trump engaged in an insurrection and his speech was not protected. He's not allowed to say that stuff because the First Amendment does not protect incitement. The Brandenburg test, which we've studied all up and down here, and they're going to say that this case law shows that his speech is not protected when you conduct a truth threat analysis. You have to decide what it means. And encouraging the use of violence or lawless action is enough. Here, President Trump threatened to deploy the military to shoot looters amid protests. Now, the district court also credited the testimony of Professor Peter Simi. As we described, Trump made a bunch of statements about this. The district court brought in a bunch of language. Trump said fight or variations of it 20 times. Wow. He said the word fight or I think he said the word fight like once or twice, and variations of it. He says, if you don't fight like hell, you're not going to have a country anymore. He said, when you catch somebody in a fraud, you're not going to have a country anymore. And all of those statements were so bad that they're not protected under the First Amendment. And they continue on. You see, the court also found that Trump issued and his tweets and his conduct were problematic. And they're going back to Professor Simi. So in sum, they say that Trump's speech was not protected by the First Amendment. They say, all right, in conclusion, the district court erred by concluding that the Section 3 of the 14th Amendment does not apply to Trump. We reverse. But as stated above, we affirm much of the reasoning on the other issues, and accordingly, Colorado, one of the most anti-democratic courts in the world, says we conclude that because President Trump is disqualified from holding office, it would be a wrongful act under the election code to list Trump as a candidate on the ballot. Therefore, the secretary may not list President Trump's name on the ballot, nor may she count any write-in votes cast for him. Okay? So a write-in campaign or anything like that, it's all dead. Now, but we stay our ruling until January 4th, the day before the deadline to certify the content on the ballot. If review is sought in the Supreme Court before the stay expires, it shall remain in place and the secretary will continue to be required to include Trump's name on the 2024 primary ballot until the receipt of any order or mandate from the Supreme Court. So that is the ruling. Now you can see this is a big, big but. That is a big old but on there because we fully expect Trump to appeal, and that will enter essentially an indefinite stay. So if Trump can hang on until January 5th and everything is stayed, his name will be on the primary ballot. But is that going to stay up through the general election? Or are they going to try this garbage again? Obviously they will. And so shout out to Chief Justice Boatwright, Justice Samore, and Justice Birkenkotter, who all dissented and did their best to preserve the right to vote for your candidates in America. These other 4 insane Colorado judges have taken away that right in theory, and we have just very limited technical limitations that are going to potentially stop that from happening. And so as soon as that happened, we heard from Jenna Griswold. Okay, she is the Colorado Secretary of State. She went on MSNBC and started in a very excited manner explaining how this was the right decision. Now, I want you to listen to her language and listen to how much platitudes you hear in her words. This is what she said after the ruling came out.
Look, I believe he incited the insurrection. There were big questions around Section 3 of the 14th Amendment, and the Colorado Supreme Court has weighed in a very loud way. Section 3 of the 14th Amendment has to apply to the presidency because if not, it's a get-out-of-jail-free card.
No, it is not, Jenna. You guys already could have indicted him. You didn't. You already impeached him and you lost, okay? And now you're trying to just take him off the board because you don't like that he's beating you currently. And so this is the guy who is behind the actual litigation. His name is Grimsley, I believe. And Sean Grimsley was working on this case, and he is explaining that he thinks they have a chance at the Supreme Court when this lands there, which undoubtedly it will. Here is what that sounded like.
Think that you have a chance at the Supreme Court?
We do. I think we have a chance at the Supreme Court. First of all, Trump is going to have to convince the Supreme Court to take this case. And I can imagine a world in which the Supreme Court says, this is pretty early on in the election cycle. Let's see how this plays out in some other states first. So he's first going to have to convince the Supreme Court to take it. And once he convinces the Supreme Court to take it, I do think we have a good shot on the substance. Again, we've got good, strong findings of fact from a district court. I think even the U.S. Supreme Court will respect and defer to those fact findings. And I think on the legal issues, we're very strong.
Well, when you're talking about you believe he'll have to convince the Supreme Court to take this, I mean, how long do you envision this playing out? How long do you think it could be before they do take it up?
Well, I suspect he's going to move pretty quickly to seek cert in this case to try and review the Colorado Supreme Court decision that issued today. But it could be that the U.S. Supreme Court says, says, you know, there are 50 states. This is really the first state that has decided this issue on a full record. Why don't we see what some other states do first?
There will be more.
Before they
the
weigh
domino
in.
effect is underway.
If this does take a long time, I think that's going to be a big question for people. And it makes me think about the arguments that were being made in front of the justices in Colorado. One of them was worried about this potential for chaos. Some states letting Trump be on the ballot, some not. Eric Olson, who is one of the other attorneys arguing this, said that any disorder he believed would be figured out pretty quickly, was the quote that he used. I mean, that does not seem guaranteed. Are you worried that this could lead to chaos?
No, I don't think it will lead to chaos. I think, again, either the court will take it up fairly quickly on this time frame with Trump seeking to appeal this ruling, or you will see another state do something in relatively short order, I would suspect. I'd be a little surprised if this issue weren't settled by the Supreme Court during the presidential primary, and certainly before the general election.
I think they
What do you make
to.
of what's at the basis of the criticism of this argument, which is that it's undemocratic and that it's the voters who should be able to be the ones who are making this decision about who's on the ballot and who's not? I mean, Chris Christie is one of the biggest critics. He is trying to take Donald Trump's job as potentially the next president, and he is saying that he thinks this is the wrong ruling.
That's the safety valve, right? You try to prosecute somebody, you make your case in the court of public opinion. If Trump's an insurrectionist, nobody's going to vote for him, legitimately. Because if Trump did something monstrous that was actually monstrous, nobody would vote for him. You have to create this whole story. And it's just a story, and people can see that. That's why people are upset.
I respect Chris Christie's view on this, but qualifications by definition keep people off ballots and prevent people from voting for who they want to vote for. So, for instance, if Obama wanted to run again, he could not, even though I'm sure there are many people out there who would love to see him serve a third term as president. Arnold Schwarzenegger could not run for president because he is not a natural-born citizen. Qualifications, again, by definition, keep people off the ballot.
Those are pretty easy to determine, okay? You're either a citizen or not. You either have already won 2 campaigns or not. This is a finding, right? Determining whether somebody has committed an insurrection, that requires a conclusion. That requires some process to come to a determination. It's not just an automatic finding, but they've decided that they could do that in their little election hearing qualification determination proceeding. That was like this weird show trial in Sarah Wallace's courtroom. So if that's the standard, then is that the standard that applies everywhere? We can just have our own little, like whatever little cabal of people want to just have a little hearing, they can do that and call that process, because it's not the same thing.
And Donald Trump is the only person to blame for this. I understand that his supporters may be upset that he could be off the ballot, but he needs to look in the mirror as to what he did on January 6th and the days leading up to it. He is the one, and it is his actions. He engaged in insurrection. The framers of the 14th Amendment after the Civil War said, we will not have people holding office who have taken a solemn oath to support the Constitution represent our country again. And he has done that to himself.
And if the Supreme Court does take it up, and they've got 3 conservative justices that were appointed to the court by Donald Trump at the center of this, you think that that conservative-leaning court is going to hear your argument and agree with you?
I do, because, I heard Ellie Honig earlier say that somehow our argument was not an originalist argument. It very much is. If you look at the originalist meaning of the 14th Amendment, it clearly covers the president and the insurrection that he engaged in on January 6th. I think the arguments that we're going to make, the historical-based arguments, are going to be very appealing to some of the conservative justices there. And I don't think they have any great fealty from a political standpoint to President Trump. They have a conservative viewpoint of the Constitution, but we think the argument we are making regarding the Constitution is a conservative one.
So I think he's partially right. I'm not sure that they do have any loyalty to Trump. I think they just want to get on the Supreme Court, and that's about it. These people are basically groomed their whole life for these positions. So I think that they're much more institutionalist than they are Trumpers. I absolutely agree with that. But I'm not so sure that it is an originalist argument, right? They try to make this seem like it is the Civil War. This is not the Civil War. This was 4 hours. This was a security failure. This was, I think, instigated by the federal government. I think they wanted this to happen so that they could just get rid of Trump and then use this as leverage to stop him from pardoning Assange, pardoning Snowden, releasing the JFK files, and so on, right? They needed leverage over him in the last 2 weeks of the election, and they got it. And that is, I think, the difference here. One was multi-year war that resulted in hundreds of thousands dead. This was a 4-year hour that resulted in Ashley Babbitt being shot and killed by the DC police. So it's a little bit of a different situation. It's not an insurrection, and I don't think that the Supreme Court is going to buy that guy's argument. But it is interesting that they are there, and man, they have been successful thus far. I thought that they had been stopped at the lower level district, but lo and behold, you go up to the Supreme Court, and the Democrats there found differently. Now, this is Jonathan Turley, another lawyer who's been around a lot longer than I have, but he's got a very similar take. He says, this is the most anti-democratic Democratic opinion I've seen in my lifetime. I couldn't agree with him more. And I was almost a little, depressed last night, just to say that we got to see another state, just our neighbors right up here in Colorado, take somebody's name off the ballot for over 1 million people in America. And they just said, well, he's an insurrectionist. Maybe that's true if you're that whacked out, but don't you want the people to be able to vote that in? If he's so bad, can't people just vote him out? Or you have to literally take the choice away from your neighbor. Okay, that's how sick these people are. And so they're doing it right now. It is a really sad state of affairs. And I think what it shows us is that the semblance of law is just evaporating even faster than we thought. They're willing now to disenfranchise 1.3 million people in order to get their way. Here is Turley.
Well, this court just handed partisans on both sides the ultimate tool to try to shortcut elections. And it's very, very dangerous. I mean, this country is a powder keg, and this court is just throwing matches at it. And I think that it's a real mistake, but I think that they're wrong on the law. January 6th was many things, most of it not good. In my view, it was not an insurrection. It was a riot. That doesn't mean that the people responsible for that day shouldn't be held accountable. But to call this an insurrection for the purposes of disqualification would create a slippery slope for every state in the union. This is a time when we actually need democracy. We need to allow the voters to vote. We need to hear their decision. And the court here just said, you're not going to get that. In Colorado, we're not going to let you vote for Donald Trump.
No.
And, you could dislike Trump. You could believe he's responsible for January 6th, but this isn't the way to do it. I mean, it is, for people that say they're trying to protect democracy, this is hands down the most anti-democratic opinion I've seen in my lifetime.
Absolutely true. And I challenge anybody to pick a different one. When else has over 1 million people who are presumably going to show up and vote for Trump, when else have they been denied that right to vote? And the Supreme Court out of Colorado just said that's the case. And so in America, we're going through some very interesting times, my friends. And so I'm very grateful that we are going through this together. I appreciate you being here as we navigate all of this madness. But Colorado is kicking Trump off the ballot. It's not going to be the first one or the only one. There's a lot of other efforts underway. We got a lot of runway left on this election season. And so we're going to be here continuing to cover this. I hope that you join us as we do. I'd really appreciate it if you brought a friend or family member over here so that they could come on when we go live and understand what's happening, grab the inside details from the right perspective so that they can use this knowledge to share with their friends and family, because we need more people to realize what's happening here. They're taking away our representation. If you can't go vote for somebody in an election, that is your representative. Okay. We have a big problem brewing. And so we're going to be here covering, my friends. Thanks for joining us as we do. Don't forget to hit that subscribe button wherever it is you're watching, and we'll look forward to seeing you on the next one.